Today's lecture is going to be on consumer protection laws. In the old 6th edition of the textbook, it was chapter 20. Consumer protection laws generally follow the same general guideline as about every other area of the law. You're going to have both state laws and federal laws that pertain to protection of consumers. For the most part, in consumer protection law area, the law is that the laws that best protect individual consumers are the ones that will govern. In most cases, that will be federal law. There are some exceptions. One of the exceptions it includes the state of California, which has very strong consumer protection laws. Alabama is in the majority of states, though, where the federal laws generally provide more protection to the consumer than does the Alabama state law. So accordingly, for that reason and for others, we're going to focus on federal law. As usual, what I'm going to do is highlight certain areas, and then other areas we'll sort of skip over as not quite as important for our purposes. You can see from the diagram that there are many different federal agencies that govern the area of advertising. You have certain agencies that deal with labeling, others that deal with enforcement in various sorts, and all of these agencies have very specific sort of areas that they are to control. General rule: advertising is okay unless, and the unless is if it has the tendency to mislead a consumer. We're going to talk about other areas of consumer law later in this chapter that deal with a different type of standard, where a least sophisticated consumer is misled. There may be some violation of federal law, but here the general rule is if a consumer would be misled. And what we're going to talk about is the objective consumer, the reasonable consumer, you and I type of person, and not the least sophisticated consumer. If, on the other hand, you are dealing with advertising that is general in nature or is mere puffery or puffing, exaggerations of sort, then those are permitted advertisements under the federal laws dealing with advertising. Example, let's say that you're dealing with a car dealership who is advertising a number of cars for sale. The advertisement goes something like this: come in to purchase our new 2013 automobiles. They are all 8-cylinder cars. They will get great gas mileage, will be the best car you've ever driven, the most comfortable car you've ever driven, and get outstanding acceleration and gas mileage. Of all of the claims that the advertisement just made, the only claim that could conceivably be one that would fall under the category of being misleading would be the misstatement of a fact, the fact that the car is an 8-cylinder car. So if you're dealing with some cars that are 6-cylinder cars or 4-cylinder cars, or cars that are different than 8-cylinder cars, then that advertisement is misleading to that extent. But what about the advertisement that claims that the car itself is a great car or the most comfortable ride they've ever had? Well, that's a matter of opinion, and matters of opinion are not deceptive. What about getting great gas mileage or outstanding gas mileage? Well, for those, again, that may be an exaggeration when they get 16 miles to the gallon, and that's not considered to be deceptive, at least not legally so. Bait and switch is another form of deceptive advertising that can be against consumer protection laws. The typical bait and switch follows this general format. Retail store or other entity advertises a product. You know the old saying about if something seems to be too good to be true, it probably is. Well, that's kind of what we're dealing with here. They have a product that's a very low price intended to lure people into the store or to the facility, and then when they arrive there, they try to get the consumer to purchase a more expensive item. Again, I am somewhat telling my age, but back in my day, I had a car and I was searching for and shopping for a new stereo system for my car. It was a little bit of a switch on bait and switch because the store there advertised a Pioneer audio system for a certain price. Well, that's the one that I went in to see. It was a good price. It wasn't an outstanding price, but a good price. And when I arrived there, the salesman attempted to sell me on another product. In that case, it was a cheaper product, a less expensive product. On the other hand, there were two reasons why the salesman was trying to sell me that product. Reason number one, they had a sales campaign where the salesman received a higher commission for the sale of that other product. Reason number two, and this is a major one for the retail store entity. Although the product being sold was cheaper, it had a higher profit margin. In other words, back in that day, the Pioneer products were all sold about the same price by all the places, and they had a very low profit margin built in. So although they attempted to lure me into purchasing a less expensive item, in fact, that was another example of bait and switch, which is illegal. Now, people ask me sometimes, well, what about these Black Friday ads where you see that Best Buy or another store is selling a product for a very, very good price, and by the time I get there, they're sold out? Well, if you notice on just about all of those, they'll say quantities limited or minimum 5 per store or something of that nature. And there's nothing wrong, of course, with advertising a very low price to bring someone into the store and selling them that product. This is bait and switch, where they're attempting instead to switch them to another product. Well, what happens when we have a violation in the advertising world? Well, when we have a violation in the advertising world, then the Federal Trade Commission has a couple of different options. The first one is the easy one. They can issue a cease and desist order. Stop advertising that your product makes people taller and more attractive to the opposite sex and lose weight and gain 15 IQ points. Cease and desist order keeps them from being able to continue the false and misleading advertisements. Second thing they can do is impose counter advertising, and that means the company will be required to submit corrective advertising that says, hey, what we said before, forget it. It's not the case. That really didn't happen the way we said it would happen. You don't gain 15 IQ points, you won't get more dates on Saturday night, and you won't grow 4 inches taller. Savvy retail entities can sometimes use this to their advantage, where they almost negotiate with the FTC regarding the wording of that counter advertising. And if you do it right, it can make the company look a lot better. Let's say that you have a company that was selling a product claiming certain health benefits that were not scientifically proven. Maybe they issue counter advertising pursuant to the FTC order, and the counter advertising says something like, gee, we have a great product. We have a number of testimonials that you can see on our website, or by specific request we can send it to you. However, after we have engaged in significant testing on our own, we have not been able to determine scientifically that the product has the claims or can back up or support the claims that we're making and have made in previous advertisings. As such, we're not going to make those kind of advertisements anymore. Makes the company look kind of like a good guy, but yet still complies with the FTC order to issue corrective or counter advertising. Telemarketing and e-advertising. What I want to focus on here is basically the first one, the Telephone Consumer Protection Act. This is actually known by another name now, and it might surprise you. Looking at what it prohibits automated solicitation using an automatic telephone dialing system or a pre-recorded voice. It says Telephone Consumer Protection Act, and we would naturally think of this in terms of unsolicited telephone calls, wouldn't we? Well, that it does prohibit unsolicited telephone calls in certain areas, but it also did something a lot more than that. And a few years ago, sleazy plaintiff lawyers that were very smart and were addressing a problem that some people had came up with another way to use this particular law. And in fact, it changed the name of the law from the Telephone Consumer Protection Act to the Junk Fax Act. Now, back in the day, all fax machines were hooked up to a telephone or a telephone line, and you would hear that unmistakable sound of the fax machine printing a new fax. In my office, we would all come and run and see what important thing was coming on the fax machine, and many times, instead of it being something very, very important, instead it was something more in the line of a lunch menu from a local restaurant, or health insurance options that a insurance company was selling, or something of that nature. Well, the Junk Fax Act prohibits unsolicited faxes being sent to businesses with whom the sender does not have a previous business relationship or consent to receive that particular fax. And the Junk Fax Act provides for a certain dollar amount of damages. I believe it's something like $500 for sending an unsolicited fax. $500 doesn't sound like much. Maybe it's $1,000. Whatever it is, it's not just that dollar amount. It is that dollar amount per unsolicited facsimile. Let's think about how this works. Companies were buying telephone numbers, fax numbers, from companies who maintained lists of those fax numbers. They were buying a list with 5,000 names on it, 10,000, 50,000, and they were sending out faxes on a fax blasting kind of system, where they might send it out to 10,000 different people in a particular morning. They considered it a very cost-effective and inexpensive way to do advertising. Unfortunately for them, it was also illegal. Hooters restaurant in Atlanta got hit with a $30 million judgment when they sent out advertisements about Hooters restaurant or the lunch specials or whatever it was to many, many different people pursuant to a list. You don't see that very often anymore because most businesses are aware of that, but please be aware of that yourself. Labeling and packaging laws, I always have to sort of chuckle a little bit when I start looking at these because I think back to growing up and seeing that tag on the bottom of our sofa. You know the tag I'm talking about? The tag that says, "Do not remove this label under penalty of law." And I'd pull that thing off and wonder if I was going to jail. Well, it's not quite, that really wasn't the intent of the law, obviously. Disclosure is the key in all of these areas. And there's various different types of laws that I'm not going to hold you responsible for knowing. But the key here is just disclosure. You must disclose content, disclose what's in particular products, the type material, etc. Let's move from advertising and disclosure to the area of sales. And again, we have a number of different protective laws that relate to sales. You don't see door-to-door sales as often as you used to. In today's world, many people won't answer the door unless they know who it is, and it has become dangerous for both the salesman and for the people residing in the home. So you don't see it that often. But to the extent they still exist, companies used to thrive on having good, strong, high-pressured salesmen show up at consumers' doors, knock on the door at their house. "Good morning, Mr. Jones, Mrs. Jones. I'm Mr. Smith with the Encyclopedia Company, and I'm here to show you why you need this encyclopedia if your child is to progress in life." I mentioned encyclopedia because that's my parents had a encyclopedia, door-to-door encyclopedia salesman sell them on the virtues of the World Book Encyclopedia. That was pre-Al Gore inventing the internet. And back in that day, that was considered high-powered research to have a World Book Encyclopedia. Parents didn't have much money, but they made sure that they had that World Book Encyclopedia for their children. Well, as a result, on door-to-door sales, and realizing that some salespeople were very pushy and very good at what they did, a federal law was put in place that gives consumers a cooling off period of 3 days, 72 hours, where they can back out of a sale made door to door. So if you had a high power pushy salesman and they walk out the door and you get buyer's remorse 4 hours later, "Oh my gosh, I can't believe I just bought a $2,000 encyclopedia when the internet will give me all the information I need." Well, you have the ability now to get out of that contract. It's not a binding contract on them. Interesting part about mail order sales that I want to mention here is the Postal Reorganization Act of 1970. Very, very interesting law, and not very many people know this. Very favorable to the consumer. Let's say that you are at home one day and you open up your mail and you have a small package. And in that small package is a very nice MP3 player. You think, wow, where did this nice MP3 player come from? And it also contains an invoice for that MP3 player. $99 payable to MP3 Acme Company. Well, question, you didn't order it. You didn't order it. Nobody in your household ordered it. You don't know where it came from, but all you know is that you've got an invoice and an MP3 player that's attached to that invoice. What do? Well, I guess you can write a check, send them the $99. You can return the MP3 player to them. Is it at their expense or is it your expense? Well, I don't know. And the best thing of all is that you can keep it. If you want to throw it away, you can throw it away. You want to keep it and use it? Fine. No problem. No obligation. If you didn't order it, you don't have to pay for it. That's what the law is. So you've just been given a gift. Thank you for that nice MP3 player. FDA governs most food and drugs. And I didn't realize this until a few years ago. I was defending a shareholder derivative lawsuit. And in that shareholder derivative lawsuit, we were dealing with a company that was in the neurological research area where they were actually doing experiments related to spinal cord injuries and devices, drugs and devices that would deliver the device that were actually helping people regain the ability to walk and doing all kind of wonderful things. Well, what I learned, and I didn't realize at the time, is that although the FDA deals with drugs and oversees that area, the FDA doesn't do the testing. Did you know that? The FDA doesn't do the testing in this particular area, but instead the companies themselves do their own testing and their own marketing, their own research, their own studies. And then they submit their studies to the FDA or to a panel of the FDA who actually review it to see if it makes sense, if it appears to be safe, etc. The FDA just doesn't have the manpower necessary to do all the kind of things that are needed. And so what they do is impose that obligation on the company themselves. A lot of potential for abuse that can exist out there. And in some cases, not many, fortunately, but in some cases, it results in products or drugs that are unsafe actually making it to the market. And I know you've seen consumer products that have actually been recalled before. A lot of times a product will hit the market, and not until consumers begin to have problems with it do they actually see the danger involved in those products. So when that occurs, then the Consumer Product Safety Act and Commission can issue a recall and require the company to not only take the product off the market, but actually to notify consumers that it's unsafe and to return the products themselves. Going to move into the final area of credit protection and debt protection. I'm going to spend more time on debt protection than we have here in the slides, so just be prepared. I also will have a separate handout related to Fair Debt Collection Practices Act when we reach that part here in a couple of minutes. Credit protection, Equal Credit Opportunity Act, Truth in Lending Act, and the Fair Credit Reporting Act. Very basic overview. The Truth in Lending Act gives certain rights to holders of credit cards. It also requires certain disclosures such as interest rates, finance charges, other fees that are associated with the cards, how interest is calculated, grace periods, all that kind of good stuff is all contained in the Truth in Lending Act, or all required by the Truth in Lending Act. The Equal Credit Opportunity Act is one of those areas of the law in which we as a society have decided that it is not right to have individuals be discriminated against on the basis of race, sex, creed, national origin, etc., for all kind of things, and providing of credit is one of those things. And finally, the Fair Credit Reporting Act is a law that says, well, yes, creditors have the right to report your credit history and items concerning or dealing with, relating to your credit history, but it must be done in a fair manner. And there are certain things that we should all take advantage of and monitor our own credit reports very carefully, because there are some rights that are given to us by the Fair Credit Reporting Act. For example, everyone is entitled to one free credit report every year. And that free credit report can be obtained, and if there are any items on the credit report that are capable of being disputed, that you don't agree with, that are just plain incorrect, then you have the right to notify the credit reporting agency, TransUnion or Experian, Equifax, and they are required to verify that information within 30 days or else. And the or else is that if they fail to verify it within the 30-day period, then they're going to remove it, or they have to remove it from your credit report. If they fail to follow the proper procedures, then there are some pretty strong damage requirements that exist in the law that provide for damages to be paid to the individual, also punitive damages, which, as you remember, are damages designed to punish the wrongdoer and to deter the wrongdoer and others like the wrongdoer from engaging in similar conduct in the future, and attorney's fees. And always when you have attorney's fees, then you'll have attorneys out there trying to help, since they see an ability for them to get paid. And the Fair Credit Reporting Act, that's what we've just discussed. Again, you are entitled to one of those free per year. You can, I don't have the exact URL, but if you are doing a Google search or an internet search for it and you get on a site that offers a credit report, and instead of it being free, there's a charge, you're not on the right government website. You need to get on the one where it is actually free. You're entitled to one free per year. And that's the part, the Fair and Accurate Credit Transaction Act, or FACT, that's the part where you actually are provided with that free credit report every 12 months. Okay, the final area we're going to discuss in consumer protection law is the Fair Debt Collection Practices Act. One thing I want to make clear about all the laws that we have talked about in this chapter, they are all federal laws. So relating this back to some areas that we've already talked about, federal court jurisdiction, what amounts would you have to sue for if you sue for a violation of the Fair Debt Collection Practices Act? Or if you sue for a federal bait and switch violation, misleading advertisement, or a violation of the Fair Credit Reporting Act? And the answer is it doesn't matter. There is no minimum amount, because all of these are considered federal questions. So if your lawsuit contains one of the violations talked about in this chapter, this section, all of which relate to federal law, then you automatically have federal court jurisdiction as federal question jurisdiction. Okay. Fair Debt Collection Practices Act, there's a couple things here that I want to focus on, and I'm going to modify just a little bit what the PowerPoint slides say, and I will have an additional handout that I may have for you at the end of this lecture. And if not, please check the Blackboard for a subsequent handout. First of all, it is another federal law, and as such, it is you do have federal court jurisdiction. It says it curbs abuses by collection agencies. Here's the first modification that I want to make. The Fair Debt Collection Practices Act is a law that relates to third-party debt collectors. So I would almost strike that out where it says collection agencies and instead call it third-party debt collectors. What's the difference? Well, collection agencies are probably 90-95% of all of the third-party debt collectors, but they're not the only third-party debt collectors. A third-party debt collector is anyone besides the original creditor, not including the original creditor, who is collecting a debt for the original creditor. Acme Toy Company sells toys to consumers, some of whom have a credit card with Acme Toy Company, and they buy toys with their credit card. If Acme Toy Company tries to collect the credit card balance due from one of its customers, the Fair Debt Collection Practices Act will not apply. Why not? Because the toy company themselves are collecting that debt. But if the toy company turns over the account to Sleazy Collection Agency Incorporated, then Sleazy Collection Agency Incorporated, when they're collecting the debt, they are subject to the Fair Debt Collection Practices Act because they are a third-party debt collector. Well, what if instead of turning it over to a collection agency, Acme Toy Company instead gives it to their lawyer and said, hey, go collect this from this deadbeat person, sue them, do whatever you've got to do. And then let's say that the attorney violates the Fair Debt Collection Practices Act. If that's the case, the attorney or the law firm is subject to the Fair Debt Collection Practices Act. Why? Because the attorney is a third-party debt collector. So the Fair Debt Collection Practices Act applies to both collection agencies and to other parties like attorneys who are collecting debts for the original creditor. Who does it not apply to? The original creditor collecting their own debt. And when I say that, if Acme Toy Company has a separate department, their credit division, and their credit manager is making collection calls, that's still the creditor themselves. It doesn't have to be the salesman, doesn't have to be the sales department. Anybody employed by that original creditor, that company, they are considered to be a non-third-party debt collector, so they are not subject to the Act. Okay, I've spent a lot of time telling you who is subject to the Act and who is not subject to the Act. Now let's see what it actually prohibits. Well, the general philosophy behind the Fair Debt Collection Practices Act is pretty simple. Creditors have the right to collect or attempt to collect the debt, but they must do so in a fair manner. There are certain things that cannot be done. first thing listed here, and again, I'm going to have to modify this a little bit. It says creditors cannot contact debtors at work. That's not completely true. First of all, creditors can do it because the Fair Debt Collection Practices Act doesn't apply to creditors. So where you see creditors cannot on your PowerPoint slide, strike out creditors, mark that out. Put down collection agencies instead, or third-party debt collectors, even better. Third-party debt collectors cannot do those things. But can a third-party debt collector contact a debtor at work ever? Sure they can. Absolutely they can, unless the debtor tells them not to do so. If, let's say I'm sitting at work one day and I haven't paid my Discover credit card bill, and Discover calls me at work and says, Mr. Cartwright, you need to pay your bill, you deadbeat. Well, if I allow them to call me there and I discuss my bill with them and I don't mind, or even if I do mind, but I don't tell them not to, they can keep calling me at work. It's not against the law. It's not against the Fair Debt Collection Practices Act. What is against the Fair Debt Collection Practices Act, if I say, I'm sorry, Discover, I'm at work, my employer will not allow personal telephone calls to be taken at work, do not call me at work anymore. Now, from that point forward, they are prohibited from contacting me at work. Creditors cannot contact debtors at odd hours. Again, change creditors to third-party debt collectors. What does that mean? Odd hours. Is that 1 o'clock, 3 o'clock, 5 o'clock, 7 o'clock? No, there's a presumption built in. And the presumption that's built in is that any phone call made after 9 o'clock p.m. is an odd hour or an inconvenient time for the consumer. Any phone call made before 8 o'clock in the morning is presumed to be an inconvenient time or an odd hour. And any calls made on a Sunday are presumed to be inappropriate as well. Does that mean that a phone call can never be made at 2 o'clock in the morning by a third-party debt collector without it being violating the Fair Debt Collection Practices Act? That's not what it means at all. Let's say that you have someone working second shift or third shift, I don't know, whatever the shift would be, where 2 o'clock or 3 o'clock in the morning would be a very normal time for that person to be up and around and coherent. If that's the case, that might be a convenient time for that particular debtor or consumer. Third-party debt collectors cannot harass or intimidate debtors. The largest case I've ever been a part of involved a Fair Debt Collection Practices Act class action. It had some other counts along with it too, but it involved a company, Payco General American Credit Company, that was a collection agency. Involved some other folks too, but Payco was the big target here. And Payco had a whole book of business turned over to them by a company called Transamerica Lender Finance. Transamerica was a business financing company who had an outstanding loan to a company, to a furniture store in Gadsden and Anniston, and the furniture company couldn't pay their bill. They couldn't pay their $2 million line of credit. And so, in satisfaction of the debt, Transamerica agreed to take all of the furniture company's accounts receivables. Since Transamerica wasn't in the business of collecting individual consumer accounts, they turned over the account to collection agency. And the collection agency began to collect the debts like they were all delinquent. Well, some of them were delinquent, but a lot of them were not. A lot of them were perfectly on time. And they began calling people and sending out nasty letters. And the calls would be, Mr. Jones, this is Payco Collection Agency. I'm calling about your furniture bill. When are you going to pay your bill? And Mr. Jones would say, well, I always pay my bills on the 15th of the month. And they'd say, that's too late. You got to pay it by the 5th of the month or else. And Mr. Jones would say, well, I don't know that I can do that. And I always pay it on the 15th. And then they'd say, well, how much are you going to pay? And he'd say, well, my payment's $35 a month. And they'd say, that's not enough. You got to pay $150 by the 5th or else we're going to sue you. Well, what they were doing is they were treating Mr. Jones' account like it was a delinquent account. And many times for a delinquent account, you'd have the right to accelerate the loan if it was delinquent. In other words, you could collect all of it. If they owed $1,000 and they were paying it $35 a month for 30 months, and they missed 3 months, well, you could tell them they owe the whole $1,000, and you could collect it the best way you could at that point. But the problem here was these accounts weren't delinquent. So, in effect, what they were doing is illegally accelerating a credit amount, a credit account, and they were trying to get them to pay an amount that they weren't legally obligated to pay. This particular case was really, really bad. They called people, talked to, in one case, a 13-year-old daughter. When she answered the phone, they asked to speak to the mom or the dad. And she told them they weren't there and if she could take a message. And they said, yeah, you tell your daddy if he doesn't pay X dollars by Friday, we're going to put him in jail. Said that to a 13-year-old. They called a lady, nice lady, Miss Virginia Ruth. And Miss Virginia Ruth, she had some issues. She had some issues before Payco came along, but those issues weren't helped at all by Payco. They called Miss Virginia Ruth, and they said, we're calling about your furniture bill. And she says, well, what about my furniture bill? They said, well, we need to have payment made or else we're going to take action. She's like, well, what kind of action? She said, you're not going to come and repossess my furniture, are you? Yes, ma'am, we may. You're not going to come in the middle of the night and repossess my bedroom suite while I'm sleeping in it, are you? Yes, ma'am, we will. Miss Virginia Ruth had a nervous breakdown, and she ended up being hospitalized because of the things that were going on with this collection agency. There are a lot of things that are worse than the one I just told you, but you get the general idea. You can't do those kind of things. We live in a civilized society, and our laws are designed so that people can collect and they can attempt to collect, but they must do so in a fair and civilized kind of manner. If they don't, then they're subject to the Fair Debt Collection Practices Act. Now, why is this law important? Well, a few minutes ago I mentioned the Acme Toy Company, and I said when they're trying to collect their own debt, they are not subject to the Federal Fair Debt Collection Practices Act. Could they call people at 4 o'clock in the morning and say, if you don't pay, I'm going to come and beat you up? Well, probably not. But the problem with this is that it's not subject to the Fair Debt Collection Practices Act. It might be illegal under state law, but the problem is the amount of damages. Are you really going to get an attorney excited about handling that state law claim against Acme Toy Company when that's all they did is they annoyed you and maybe scared you a little bit, and that's all that happened? You're probably not going to get an attorney excited about filing suit and spending thousands of dollars of time to handle the case when the odds are that he or she will get a contingency fee percentage of a very small amount. This is why the Fair Debt Collection Practices Act is important. If you're subject to it, then it applies and it allows damages to be recovered, whatever actual damages are. Miss Virginia Ruth could show a lot of actual damages because she had medical expenses and a nervous breakdown. Most people, the actual damages are going to be very small. They're not going to be able to show much. But they can also receive statutory damages. Again, not a whole lot, limited to $1,000. And then here's the kicker, final part of it. In addition to actual damages proven, in addition to statutory damages, the Fair Debt Collection Practices Act also allows attorney's fees to be paid. So, in effect, the attorney who handles the case can bill them for all the hours that he or she spends in proving the case if they win. That's why you'll have attorneys that will be interested in pursuing claims for violations of the Fair Debt Collection Practices Act. You will get them interested because they can be paid. That's all we have for consumer protection. Please check the Blackboard for updates and for the additional handout on the Fair Debt Collection Practices Act. Thank you.